Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Recently, I was asked a question which basically amounts to, do I still have to report changes to my AR-15 within 30 days to the registrar? And as a law nerd, that was kind of a neat question, because the first thing I thought was, that raises some interesting issues. So, as you may have gathered if you watched my videos, I am a total law nerd, and in particular a firearms and weapons law nerd. So I went and dug into this because there's a few different directions this can go. Let's first look at the Firearm Registration Certificates regulations. This is a set of regulations that is under the Firearms Act. And the section that is sort of most applicable here is this section, 4.1 and 4.2. So this provides, subject to Section 5, and we're not going to need to worry about Section 5 because that only applies if you're a business. So subject to Section 5, the registrar shall attach, and remember, shall is legal language, which means must. They don't have the option. This is something they have to do. Shall attach to a registration certificate that is issued in respect of a firearm the condition that the holder of the certificate shall advise the registrar, so again, must advise the registrar, within 30 days after the modification of A, any modification to the firearm that results in a change of class of the firearm. In the case of a firearm registered as a frame or receiver only, any modification that makes it capable of discharging ammunition. Any modification to an altered automatic firearm. And any modification that results in the firearm ceasing to be a firearm. And also, they shall attach to a registration certificate that when the type, action, caliber, or gauge of the firearm is modified, the holder of the certificate shall advise the registrar of the modification, either A, if the modification is intended to be permanent within 30 days after the modification, and if it's not intended to be permanent but still exists 30 days after it's made, without delay after that period. Now, in terms of conditions, conditions actually have a fair bit of teeth to them. If we look at the Firearms Act, we can see contravention of conditions, licenses, etc., any person who commits an offense who, without lawful excuse, contravenes a condition of a license, registration certificate, or authorization held by the person. And the punishment for that is up to 2 years if the Crown proceeds by indictment, or they can proceed by summary conviction. So that's a bit of a big deal. Not complying with a condition can also be grounds to revoke a license, a registration certificate, or the like. However, this gets interesting because the way they did this was not by saying that there is they didn't put into the criminal code that there's a requirement that you notify them. What they did instead is that they used these regulations, which were a legislative shortcut, to require the registrar to impose these conditions onto the registration certificates. Now, one thing you might be thinking is, wait a minute, didn't the registrar of firearms send me a letter about my registration certificates for my AR-15? Which indeed they did. They take the position that these were nullified. Nullified, of course, is not a thing that's described in the Firearms Act or the regulations or anything else. It appears to be a term that they have invented. In my view, the proper interpretation is that they have attempted to revoke the registration certificates. Well, either way, the position of the registrar is that your registration certificate is not valid. And if it's not valid, then the conditions imposed on it, I don't see how they could be taken to continue to bind you. So I think they've got a bit of a problem in, a lesson in unintended consequences here, because I don't think that they meant to say that you didn't have to follow these rules anymore. But once they say that your registration certificate is not valid, how can the conditions on it still persist? I think that's a bit of a problem for them. So I think that obligation may have been terminated. Now, I say may because whenever somebody asks a legal question, the answer is almost always, it depends. Because the ultimate interpretation of that particular question as to whether or not those conditions can survive the death of the certificate is something that would be handled by a court. A court would have to make that determination. The other question that comes up here is whether or not it would actually be an offense to take these steps in question, which in this case was to strip an AR-15 down from the full assembled firearm into its constituent parts, which would get you an upper, a lower, and then the various accessories. Now, there's various reasons why people might want to do that, but the issue that comes up here is, from my view, in terms of the amnesty, which the amnesty provides for you to do certain things for, possessing it for specified purposes. And the purposes that are listed out include deactivation of the firearm so that it's no longer a firearm or no longer a prohibited device, delivering it to a peace officer for destruction, delivering it to its owner if it's held by somebody who isn't the owner, and so on and so on. Now, disassembly of the firearm or assembly of the firearm is not actually listed in this category, but so ultimately this is going to get into a real question of interpretation, because the question then becomes, if somebody does something with it that is not one of these specified purposes, but they're still possessing it for this purpose, which most of us at this point are possessing it essentially while waiting for, waiting for a buyback or waiting for some change in the legislation here. So if you do something with it that's not just only that, does that take you outside of the amnesty? And the question of that is a big maybe. This is one of those interesting questions where interesting is lawyer speak for expensive. Interesting questions are ones I would love to litigate. They sound like they would be a lot of fun, but you would not want to litigate as the person involved, because when the lawyer's having fun, you're spending money. It's on your dime. So that's not really a place you want to be here. I also think that the likelihood of a court coming to a decision one way or another really kind of depends on what you're talking about. So for instance, if you took one of these guns out of your gun safe to take a picture of it because, you really wanted to remember it before, whatever happens to it happens, I'm not sure that I would see a court being terribly inclined to find that that meant that you were committing a serious criminal offense. However, if you went and then, took it to the range, they might be more inclined to find that that involved committing a serious criminal offense. And if you went and took it to rob a bank, I'm pretty sure that at that point they would say, yeah, you know what? We have no problem determining that you are outside of this amnesty and tacking on some additional criminal charges as a result of that. So this is one of those questions that I'm not sure where a court would go. And you never want to be in a court where you don't really know where the court's going to go, because again, expensive. And also, anytime you're talking about a criminal violation, you've got a lot at stake if you're ending up in front of the court. You've got the potential of, a criminal record. You've got the potential of jail time. You've got the potential of a firearm prohibition, which costs you, your firearms and your ability to possess them. So it's a big deal. So I can't really answer this question one way or another, but it does raise some neat sort of legal issues. And in particular, this issue of, did they accidentally remove those conditions when they nuked the registration certificates? I kind of think that, my inclination is to say that they must have. And again, I don't think they meant to. So a little bit of a lesson in the law of unintended consequences. So ultimately, as with most things, I suspect my answer is going to be a little unsatisfying, but I hope you've enjoyed sort of sticking with me as I kind of walk through it and play with this idea. It's a fun idea. Anyway, thank you for watching. I am going to link the relevant legislation that I've cited here in the description below, so you can have a look at it yourself, see if you come to a different conclusion. I also am going to have a link to my Discord. If you want to hang out, I'm often there and you can chat with me. Or if you want to donate on the Patreon. I want to thank my patrons at the $50 level: D. Mo, People of Canada, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, and Toronto Airsoft. At the $20 level, Cameron Johnson, Kevin Fleet, and Dale Nesbitt. And at the $10 level, a lot of you who I'm going to thank in the crawl immediately following. I've got a bit of a sore throat today, so I don't really want to go through all of that. My apologies. But thank you once again, and I hope this has armed you with knowledge.